Hello and thanks for staying with us. Welcome to Political Platform on Power Radio and Africa Independent Television, AIT. My name is Amechi Anapwe. Now, the appeal court ruling staying execution of the judgment of a federal high court ordering the Independent National Electoral Commission, INEC, to deregister 5 political parties has calmed tensions in the country. An outrage followed the decision of Justice Peter Lifu, the Federal High Court judge that ordered the deregistration, with many pointing at existential threat to Nigeria's democracy. The Court of Appeal, in its ruling, did not spare Justice Lifu for his action. It held that Justice Lifu's decision to deliver judgment on the matter, despite the earlier Court of Appeal order directing him to suspend further action, amounted to a serious breach of judicial hierarchy. The appellate court described the lower court's action as the highest form of judicial impertinence and judicial rascality, and ordered a self-execution on the deregistration. It also described Justice Lifu as unfit to sit on the bench. Now, the appellate court, senior justices calling out a judge sitting at the lower court, calling him all the names with all the adjectives negative. At the end of the day, they said he is unfit to sit on the bench, meaning he is not fit to continue to sit in court over matters. So, National Judicial Council, is it not over to you? As some persons, some parties, some lawyers have said, they will be firing, using our local parlance, firing petitions against Justice Lifu. So, temporary reprieve for the 5 political parties that were affected. We will examine the developing situation. We will be joined by Monday Obani, a senior advocate of Nigeria. We will interrogate the basis for the judgment delivered by the Federal High Court and the role of the judiciary in Nigeria's electoral system. Okay, the Nigeria Democratic Congress, NDC, is mandating all its candidates running for elective offices to sign a strict indemnity and anti-defection affidavits. In the affidavits that all the candidates must sign, they will commit to vacating their seats and forfeiting their mandate if they defect from the party after winning the election. Any candidate that refuses to sign will not have his or her name uploaded to INEC portal. Very interesting situation that demands examination. We shall be doing that here. And the Senate has summoned lawmakers to an emergency session on June 23 to deliberate on national security and other pressing issues of national importance. The purpose of this emergency sitting is to enable the Senate to consider matters of urgent national importance, particularly issues relating to national security and other critical concerns that require immediate legislative attention. We'll break down this for you. A fire brigade approach again. One thing with Nigeria is that a culture of fire brigade has been enthroned. Those in authority will watch events unfold, will watch things degenerate. They will either pretend they don't understand or they look away. But when it gets to a critical point, you begin to see fire brigade action, like, we are used to. Run here from pillar to post, trying to fix a problem we saw develop and all that. Is the Senate not aware of the security situations in the past? Yes, they may have taken some action, but did they take drastic action that they intentionally want to take now? Anyway, let me bring in my colleagues, Shola Jaisimi and Mustafa Mohammed. Welcome to the program.
Thank you.
Okay, yeah, Mustafa.
Thank you very much, Amechi. Good morning, viewers. You see, the higher court, castigating and calling that judge names was what I personally expected if these 5 political parties decided to go and appeal. And of course, NDC, they said the soup in the other compounds kitchen, if the aroma is sweeter, even if it doesn't attract neighbors, it can attract flies. So if you hear about defection, 90% of the defections usually happens when people go to the APC.
The ruling party.
Yeah, the ruling party. I think the soup there is sweeter. So I think it's timely that the NDC is taking such steps at the moment.
So we spoke here at length about Justice Peter Lifu's, ruling or judgment or verdict, as the case may be. And we looked at what he had ruled on. And we said, yes, the Court of Appeal needs to come in urgently.
And it did.
It did. You've set the tone for what should happen. If the judge thinks that his pronouncements were in accordance with the law, the National Judicial Council, which looks at judges who err, will decide his fate. We're not saying he needs to leave the bench, but our judges need to...
He needs to, if need be.
No, what I'm saying...
If the decision is for him to leave, he should take a walk.
Well, my point is that there are justices who have taken a decision and they feel they have a right cause to take that decision. But the High Court, the Court of Appeal has reminded us that we had told you earlier, that's the clincher now,
yes,
that you needed to have waited for us on this matter. Why did you rule on this?
There is error of judgment. You can condone that. Yeah. But when it's a misconduct, then it calls for punitive sanction. But let's indeed take a listen to the reaction of some lawyers that were at the Court of Appeal on Tuesday in Abuja. Okay, apologies for the loss of audios. Production team would double check on that and will surely indeed share the reactions of the lawyers with you. They were outraged, they were surprised, some of them saying in all their time up to 25 years at the bar, they have never seen such a rascality as displayed by a sitting judge.
We are lucky that we have the National Judicial Council, and they don't take it easily when there's a judicial misconduct by a judge. And of course, they have their disciplinary action, they will investigate. And if they also found him guilty, Nigerians will be really very happy to see that he is removed and stopped from further sitting as a judge. We all know that, like all sectors of this country, the judiciary needs to continue to cleanse itself. They said the court is the last hope of the common man. So such people would misconduct should not be seen to be sitting and adjudicating a matter. This is, yesterday I spoke about ABN Association of Better Nigeria, the judge who gave that verdict that destroyed the June 12th election and what have you. We might have many more, but with time they can expose themselves, and we'll be glad to see that they are pushed out of this.
Even a layman, as unlearned, so to say, as we were, we understood that once a superior court makes a pronouncement, do this, do that, you have only one option. You have to obey. Only one option. And that's to obey. The same way we have always said on this program, that even any judge, be it a magistrate, a customary court judge, makes a pronouncement as stupid as you think it is, you must obey. And it was good that
Even when
was
he's
obeyed,
drunk.
and the parties involved went to a higher court to have that quash, at least temporary, with a stay. These are the right steps to take. You don't need a lawyer to know the right steps to take.
Well, I would like us to be very careful on the program so that we don't convict Justice Peter Lifu, before petitions go ahead of this issue that has occurred. We'll watch the fray. We have condemned,
No, we are just reiterating what the justices at the Court of Appeal said.
Yes.
We have not brought in any new thing.
And if the verdict is there, it's
Yeah,
open.
but the justices of the Court of Appeal are not the National Judicial Council.
Yes.
That's the key.
That's why we said over to National Judicial
Yeah, so if
Council.
the NJC summons Justice Peter Lifu, he will answer the questions and he will know whether he will continue to sit as a judge of the Federal High Court. Now, we're told that those lawyers are now ready to
Yes, so let's take a listen to the reaction of the lawyers at the court.
To protect the interest of justice belongs to every member of the bar and to their lordships. Close to 30 years in practice and more than 25 years, but I've not seen a direct affront like this one. So that's why we complained about it.
The judgment was delivered without jurisdiction. From the moment the appeal was entered at the Court of Appeal, the Court of Appeal became seized of the jurisdiction in that matter to the exclusion of the Federal High Court. So the Federal High Court had no jurisdiction to have sat over the matter and deliver the judgment that it delivered.
Due to the INEC timetable and considering the fact that the election is approaching, the court has fixed the 25th of this month for all pending applications to be determined on the final.
The events leading up to this, that is about the registration after the process of election have commenced. Election is not an event, it is a process. The day the timetable was rolled out by INEC, INEC already know who and who will be part of the process of election.
From the lawyers. Anyway, let's go to another issue. We'll get in our guest, a senior advocate, to weigh in on this and the role of the judiciary in our extended electoral system. But let's quickly take you to the Nigeria Democratic Congress, NDC. The party, one of the two new parties that were registered by INEC just some few months ago, hit the ground running, so to say, after some big politicians indeed joined his ranks. But he's coming out with something new, keeping an eye on possible defections as witnessed by other parties after the 2023 general election. Labour Party, PDP and others, NMPP, lost their members in droves to the ruling party in the guise of defection. Now, NDC is saying, before we upload your name as our candidate on INEC portal, you must sign some documents, depose to an affidavit in court, saying that you will vacate office if you defect before your tenure ends. If we have a sound from what the party is saying, okay, we don't have it yet. My colleagues have some perspectives.
You see, if you look at the history of this current dispensation, starting from 1999 to the current period, most politicians have defected from one party to the other. Of course, we give credit to former President Obasanjo, Goodluck, Jonathan, Iradua. They were there where they were elected. But then whether it's General Buhari and many others have kept jumping or changing parties from one party to the other. I still remember the famous cliche our colleagues use, Ehedo and Yago, jumpology, in terms of people in politics or economy usually look for where they would think they will be fortunate if they go to. And that attracts decamping from one party to the other. But it's also a very good development for the NDC to take such a division so that people don't just use their platform and abandon them, because that has happened several times. The laws only provided that it's only when you have factions and crises in your party that you can jump to another
But they
party.
seem to have a way
to
go around that.
They always have a way. In fact, you can even sponsor others to create a faction and then you jump out.
Even in your ward.
Yeah, but then I think the delay in uploading the names have given them an opportunity to do what they have just done. So we'll wait and see who and who among the NDC candidate that will fail to sign that agreement. Of course, they will still also find a way of replacing whoever that is not willing to follow as they want. They can go to court if anybody goes against that agreement.
Sholaja Sime, we know that this position belongs to the party. On election day, if you take a look at the ballot paper, you won't see the picture of any candidate. Neither will you see the name of any candidate. It is the party name, acronym, and logo that you see. So the seat belongs to the party. Perhaps NDC is trying to hold on to what belongs to it.
The first thing I'll say is this. The national leader of the NDC, former Governor Seriake Dixon of Bayelsa State, before he became a governor, he was a member of the House of Representatives. Now he's a senator. Not only that, he's a lawyer. Not only that, he used to be in the Action, what's that party? AD. The Tinubu party way back. We went with 5 governors when we started. Alliance for Democracy. Way back when he started.
The national officer.
Exactly. In 98, 99. Very young man. Eventually moved to the PDP.
He was also in the police service.
So I'm laying all of this to let us know that even those who are at the helm of affairs...
I think he was also Attorney General in
Bayelsa.
In Bayelsa.
Yes. So he's been there, he needs to. So as a leader of the party, he's looked around and probably said, oh, when I jumped ship those days, things may have favored me. Now I lead a party as the founder and national leader. Let me do things whereby our new party doesn't have those who will be jumping right, left, and center. But something we must bring to the fore clearly is the Constitution. If they sign an affidavit, the strength of that affidavit vis-a-vis the Constitution. Number one, the Constitution as we currently have now gives room for persons to dump a party if there's crisis in that party, as Mustafa has emphasized. Number two, if you don't get what I'll call, or what the National Assembly will call, I'm trying to make this point, but let me get back to the main thing I want to talk about, which is that how valid. Our guest will tell us.
Yes.
He's a senior advocate.
Absolutely.
He is also a former national vice president of the NBA. How valid will an affidavit you swore in court to the Constitution? Which one will have
placed side by side with the Constitution?
Exactly. If somebody says he gets a ticket night to the NDC, signs that affidavit, wins the election, whatever the position, and an
affidavit will also be deposed in court.
Yes.
So will it be a form of consent judgment, or perhaps he will explain all this?
He will explain. So we're raising all of this so that we can critically look at it, not just because it sounds like a novel idea, then everybody thinks that's the end of it. We'll touch on that.
Quite interesting legal matters and parties. In my place, they say if a bird learns how to indeed fly without perching, we all know the saying, the hunter learns how to shoot without aiming. So parties trying to safeguard what belongs to them. But the issue is that the law is very clear on what should happen if you defect. The problem is that those that are to implement the law are not guided by patriotic interests. They are guided by selfish, narrow party interests. The presiding officers in the National Assembly, the Senate President, the Speaker of the House of Representatives, if they implement what the law says, once you defect and in their own understanding and interpretation there is no division, they declare the right to INEC. Ask him to begin the process of conducting a by-election to fill a vacancy that they can declare your seat vacant.
Yeah, you focused on the lawmakers, either state or federal.
Yes.
The thing about it that in the Constitution, it is silent about executive decampment. Governors, presidents, deputy, and all of that. It's quite silent. So, by Monday Ubani will...
Yeah, it's silent, but there's a provision in the Constitution. The State Assembly, the National Assembly, if a sitting president or a governor defects, they can consider it to be an impeachable offense.
No, punishment.
That's what I'm saying.
It's not clearly there. It's not clearly there from what I know. So
yes, for the executive.
So from 1999 to this very period, if you look at the the constitution given by the military for the democratic experience to start under General Abdusalami Abubakar, who just launched his memoirs or his book, you discover that there are a lot of loopholes. And before you get a perfect constitution or near perfect constitution, because you can never get a perfect constitution, if the review change it, many of the national assemblies will come, look at the issues, they will start, the exercise will not finish. Another set will come, they will start, they will not finish.
No, but there have been 2 alterations which have succeeded.
But the various sections and issues that required, transformation, many have not been addressed. I can give you a few examples. What happens if a president was away, whether he was ill or he...
For 21 days.
For 21 days. It was much later that issue was other than the issue of Abubakar Audu, blessed memory, as a candidate of the party, passed away and what have you. But it's not just about election. The Nigerian constitution has a lot of issues to address. And we hope and pray that we can have National Assembly, brave National Assembly men and women who can look at this constitution, loopholes in the face, and make sure that they carry out changes that are needed between 3, 4, 6 months. However, where they will have a lot of problems is the state government, the state assembly trying to, protect the interests of their godfathers who are the governors. That's why a lot of things cannot say. Look at even the issue of Child Rights Act could not be domesticated in many states because some people felt it should not sail through. So in our electoral and political system, we really need those reforms that can turn around our electoral system.
So talking about the constitution and the amendments, funny enough, if you approach your work without being guided by national interest, without being guided by patriotism, one day you'll be out of government and you may be a victim of such. Yeah. A key example is the last alteration of the constitution. It was done under Abubakar Malami, a senior advocate of Nigeria, who was chief law officer of the country then, Attorney General of the Federation and Minister of Justice. He was in office, he was in power, and under his tenure, he advised the president to sign an alteration of the constitution that empowers a court to order INEC that empowers INEC to deregister a political party. Perhaps they took the action that time because they felt they were in power and they can use it against any party that poses a threat to them. He forgot that one day he'll be out of power. Now, it didn't take long for him to be out of power, and he found himself in ADC. And that constitutional amendment was lashed on by a high court
against his party,
INEC, to deregister his own party. So it tells us that when you're in office, know that power is transient. You cannot be there forever. And talking about our constitution, must everything be in our constitution? There are countries that operate without constitution.
Of course, like
some
the UK.
Countries have unwritten constitution. You only need common sense. Common sense to guide you that this is right, this is wrong. So we intend to over-constitutionalize ourselves. Every time we look at the constitution, every time it's not there is no situation that you cannot find a solution if you bring rationalism and common sense into it.
Amechi, you're a political scientist, yes. And those of you in your sphere say that there's a need to have a body of rules that will help society to remain sane.
Absolutely.
Where there is no law, there's a resort to anarchy. So it helps us as a country with different people, different perspectives to life, different political viewpoints, ideology, perspectives. If a country such as Nigeria doesn't have a constitution, it will not help us. There will be chaos. There will be confusion. So I push, and I'll continue to subscribe to us having a constitution. We have one already. Whether the amendments that are made, like you've emphasized, help the people or they are primordial or they look in certain direction is what we need to focus on. So if we need to continue to amend our constitution for the greater good of many, I will support that anytime, any day. However, those who do the amendments. The National Assembly, the State House of Assembly, and even the executive arm, the president will sign. They need to look themselves, not in the mirror, but probably go to a stream and look at the reflection in the water and ask themselves that this set of laws that we are amending, is it for us? Is it for our party?
Like they did with the Electoral Act. The National Assembly politicized the Electoral Act to suit certain interests. They were not looking at Nigeria. And I agree with what you said. I don't mean that we don't need a constitution. We need a constitution as a guide, but beyond the constitution, American presidential system, what's the number of pages in the US federal constitution? Less than 10 and all that. But it's not just about the big document. It's about the morality, the rationalism you're bringing into it. And perhaps time for us to go on a break. And when we come back, our guests will join us to help to bring in expert and legal perspectives to the issues on the table. Do stay with us.
Old new chapter in political discourse. The conversations that matter most are stepping into the spotlight like never before. Political platform, the hard-hitting, no-holds-barred program you have trusted on Raypower Radio is making a powerful move to television. Tune in to Africa Independent Television, AIT, as political platform debuts on your screen, bringing deeper analysis, sharper debates, and the voices shaping our nation's future right into your screens. From policy and politics breakdowns to real-time discussions with key stakeholders, this is more than a program. It is where opinions are tested, truths are uncovered, and the people's voice is heard. Join seasoned hosts and expert guests as they tackle the issues that define our democracy. No filters, no distractions, just real talk. Political platform now on AIT, 9 to 10 a.m. every weekday. Stay informed, stay engaged, be part of the conversation.
The stories now break online. Don't miss anything from our real-time updates and exclusive content. Follow and participate in discussions on live TV studio programs to shape the narratives. Subscribe, engage, and share from AIT.live at AIT_online on X, AIT Online on Facebook, official AIT Live on Instagram, TikTok, and Threads on YouTube. Stay connected with AIT on air, online, live.
Thank you so much for staying with us. Our guest is here with us, Mondo Bani, Senior Advocate of Nigeria. Thank you so much for joining us.
Thanks for having me.
Senior Advocate Subani, let's start our conversation with you with what occurred in court yesterday. We've tried our own best. I don't know whether you're doing a law program. I don't know whether Mustafa is doing one. But we're trying to ask you, sir. Justice Peter Lifu's pronouncement and the Court of Appeals throughout, so to say, of what he did on Monday. How are those of you who are silk reacting to what has occurred?
Yeah, you are very correct. The matter is before the Court of Appeal now. And so for us as lawyers, we exercise, some level of circumspection, in going into the, probably our own opinion as to what the court should have reached as a decision, So the position is this. What I understand that what the Court of Appeal did was to show high level of anger with regards to an existing court order from the Court of Appeal asking...
An anger that is uncommon.
It's uncommon, very uncommon, for such a judicial language that was used against a lower court justice. So they are of the opinion that there has already been an existing order of the court, and that order was made after hearing parties, all parties on notice. It was an order made that is interlocutory, staying proceedings. When a higher court is seized of the matter like the Court of Appeal, they are now seized of that particular matter that is before the Court of Federal High Court. Then you don't have any jurisdiction bonds, until the Court of Appeal determines whatever have brought the appellants before that court. So when they say stay proceedings, they have not gone into the substance of his judgment, mind you, there is appeal already.
Yeah.
And they will consider the merit of that appeal. But what they did yesterday is to stay execution of that order. They stayed execution of that particular judgment pending the hearing of the substantive appeal, whereby they will look at what Justice Lifu has pronounced in terms of judgment. What was critical was the issue of Section 225A, which all of you have analyzed. What is it saying? What is that judgment saying? That judgment is saying that INEC has power under the law. INEC has power under the law to deregister political parties.
Yes.
And that power is exclusive
To INEC.
to INEC.
So is it a decision of INEC or can a court,
No.
by order of mandamus,
Let's look at the
ask
broader.
INEC to
Let's
do so?
look at the broader issue. In the Electoral Act, even in the Constitution, INEC's independence is guaranteed. The law says INEC should not be interfered with in the exercise of the executive power. I mean, power that have been given to them to organize election and all that. Even the executive cannot. It's there in the Constitution. Whether it is ephemeral, whether it is substantive and all that. But the point is that is guaranteed. We are looking at the substance. We're looking at the substance of the provision, right? Now, in exercising that power, neither the court, neither the executive should interfere in that process. It's only when they have exercised their power, then you can now carry out what we call judicial review of that exercise, whether they are in compliance with the law or whether in violation. But for you now to substitute the decision of an independent body that has been given power, it is unheard of, but it's something that the Court of Appeal will look at to know whether such. But let me also assure you that the power of INEC to deregister political parties has already been affirmed, even by the Supreme Court. There is no doubt about that. But what is novel in this one is whether another body can now direct INEC to exercise that power. Even when INEC said we have exercised the power, we have carried out what we call administrative evaluation of these parties, and we have found them not to be invalid.
So the initiative has to come from INEC.
That's what
If it comes from the court,
Look at this section. Section 225A says, INEC shall have the power. It didn't say INEC shall deregister. There's a difference between INEC shall deregister.
It's compulsory.
Beautiful. But when it says INEC shall have the power to deregister, it means that there must be an administrative function to be carried out by that independent body that has exclusive power to do evaluation of a political party, whether they qualify for registration or whether they also qualify for deregistration.
Now let's look at registration.
Yes, sir.
INEC, what does it say? Did it say INEC shall have the power to register? Because courts have given judgment ordering INEC to register political parties, and they did so.
Let me tell you, even in doing that, if the court has asked INEC to go and deregister, it gives INEC still the power to either deregister or because that evaluation process is theirs. But what is very strange, because even though we have not seen the disembark form report, the court now went ahead and said INEC should not receive any of their candidates for election. And INEC should not in any way allow them to participate. So the court has already taken a decision. So it is the court that actually is registering them, no longer INEC. Because it's INEC that has that right to deregister and now say, we will not take your names, we will not also deal with you. So that's the difference.
Let me find out from you.
Registration.
On registration.
If courts, Mustafa,
Yes.
if courts can order registration by INEC, why should we not order deregistration?
See, when they order registration, I keep on saying it. It is when they go to court, they will outline in their facts that there is a requirement for registration.
That's the plaintiff.
Yes, sir. And that they have complied with all that. INEC has a right now to bring their counter affidavit and say, no, you have not complied. But if INEC's opinion is evaluated by the court and the court found out that this particular person or body has complied with all the requirements for registration, the court now makes a pronouncement. I hope you get it. Listen, because INEC will say, oh, they are qualified or they are not qualified. They still have to file a paper. In this case, INEC also filed a counter, remember? And saying these political parties you want us to deregister have complied with the provisions of the Constitution. So you have to take into consideration that particular fact and evaluate and say, based upon this, go and deregister them if they have not qualified, because you found that, not qualified. But in this case, the court was now saying, go and deregister despite your counter. So the ones you're asking me whether they have a right to register, they have a right to register if the people that have come to court to canvass registration satisfy the court that all the requirements of registration we have complied with it. Look at our law. What did the law say we should do? We should have an office here in Abuja. We should have all over the federation. Look at all the addresses. Look at the number of members that should be there. We have it. Look at our register. So when the court now examines that this particular party is in compliance, what do we expect the court to do? Say, based upon the right of association, which is a guaranteed right, you are going to be go and register them. So it is only when the court finds out that they are not qualified, and INEC is saying so, they can also say don't register them. So we must make that distinction. Because INEC will always file a paper. What did INEC say wherever they say go and register? If INEC did not file any paper showing why they are not qualified to register, so what will the court do? The court will say go and register them in the circumstance because they are qualified.
The matter of in the Court of Appeal,
Yes.
that there was a directive by the Court of Appeal that
Yes.
the lower court should not
Stay a precedent. Say don't go on.
Have that judge gone beyond his brief, and how common does this kind of going against a higher court directive happen in the judiciary?
There is issue of what we call judicial precedents. Stare decisis. The law of stare decisis is that you obey the decision of a superior court, whether you agree with it or you don't agree with it. If you even want to disagree with a higher court decision, you can only distinguish it if you are capable of doing that, because the facts are not similar and all that. You can't distinguish. But when a higher court has made an order for a court below to comply with, it is not right to ignore it, because I understand that particular situation was pointed out to the judge. That's
why the lawyers were canvassing.
Yeah, we're canvassing that there is already a pending appeal over this matter, and we have an express order that you should stay proceeding. It was to his knowledge. So that is why I'm not going to make any conclusive statement concerning whether he is guilty or not. It is a body that will now look at it, because they will ask him and give him a fair hearing. Why did you have to? Was this brought to your knowledge? And if it was brought to your knowledge, what was your reason for going ahead and all that? So he may give an explanation that may satisfy the body.
That's the NJC. If a petition is presented.
If they want to go into all that, maybe a petition and all that, somebody, okay, they will invite him. There was an existing order by the Court of Appeal, and you are aware of it, or you are not aware. So he will be in a position now to say, I wasn't aware, or I was aware. And then even if that I was aware, this is the reason why I did what I did. So there must be a fair hearing also to him.
Okay, let me take you back, because we need to make it very clear to our listeners and viewers.
Yeah.
Powers of court to order registration of political parties, and
Yes.
powers of court to order deregistration. From what you have said,
Yes.
it appears the Constitution leans towards, based on the fundamental right of freedom of association.
Yes.
It's easier for the court to order a formation of a political party than it protects that
Than to destroy.
party.
But it's not better to build, rather.
Yes, that destructive power.
Yeah.
The Constitution appeared to push it back. But for the NDC matter,
Yes.
Nigerian Democratic Congress,
Yes.
the bone of contention was that two issues. INEC said your logo is similar to that of a broom, the APC, which the court, from what I heard, the judge even asked those that were in court to look at the two and see whether there's a distinction. And all of them agreed that there was a clear distinction. The other issue was that the lawyers to NDC said they have satisfied all that they wanted. Offices in social places, this and that. Now, speak to it so that it becomes clear to everybody that perhaps the Constitution is protective of that right to associate and protects the association from being dismantled by certain interests.
There are other considerations, even when you are giving a judgment as a judge. You consider the broader issue. Constitution is meant for societies that are ruled by law. And so there is philosophy behind lawmaking. Even the constitution itself.
That's the spirit of the constitution.
There is a spirit of the constitution. So the broader picture in every consideration is that it is better to keep alive than to destroy, right? And so that's why most times when it is to keep alive, you see activism, what we call judicial activism.
Yes.
You see the relaxation of rules, restrict approach. We'll talk about maybe a local standard later, because it's very important we talk about this issue of locus of those who came to court and what the court did, by dismissing the premier judge. So there is this broader issue that the court consider. It's not only the strict application of law. When a judge sits there are many things that comes. Recently, there was a judgment, even though funny, that was given in Lagos where the judge was talking about the economic hardship. That people are suffering, that legislators cannot be driving such cars when there is economic hardship. So he has brought economic hardship. It's a decision that I will take time to write a thesis.
Morality?
That's morality he has brought into law. Are you following me?
Yes.
It's a particular case we have to look at, and that is another judge in Lagos that gave that decision recently. He brought it.
That's an activist.
That is an activist judge. That is activism into play.
That's what we need.
Well, that is what he's saying.
Yes.
You see, but then we must also remember the jurisprudence, because I did a thesis recently on the issue of local standard as an impediment to public interest litigation in Nigeria, and my finding is that the present position of our law is still a restrictive approach. Ibrahim Adesanya's approach, even confirmed recently by the Supreme Court as recently as 2025 in Ganifa Emir Okonji-Iweala, that you must establish personal injury in public interest before they can hear you, before you can have access. Even though some of us who are public interest litigants are
You must have local standing.
Advocating for liberalization, which is what Indian judiciary has done.
Yes.
Kenya.
They've done the same thing.
Then the same with South Africa. They have the constitutionalized standing in their own constitution, giving broad standing that even individuals or organizations can sue on behalf of a third party without establishing personal injury. But Nigeria is still saying you must show that you have suffered over and above every other citizen before you can succeed. That is the present law. So this activism of our lower court judges is a good development, but the point is that is not the present jurisprudence, because the issue of the final court determines the jurisprudence in any country. They say they are final. They are not final because they are infallible. I mean, they are not, they are not final because they are infallible. They are infallible because they are final. And whatever they have pronounced is the law. So the jurisprudence today with local standard is still a restrictive approach. That's a era.
Let's go into issues of party politics, from another perspective. The Nigerian Democratic Congress, it has unveiled, that said that, look, all of you who have won our primaries, before we present you as candidates to INEC, come and sign affidavit that you will not jump from our party to another one. Can you weigh in on this, Barrister Obani?
Yes, the Constitution says for legislators, not for governors, that you cannot actually go to another political party after you've been elected under a particular platform, except you can prove that in that your party, division, give you an exceptions and all that. Is there. And it has been very difficult, getting members to lose their seat based upon that. And in naked debate, as rightly pointed out, says when men have learned to fly without patching, they have also learned to, shoot without missing. So this is novel, and maybe a subject of judicial interpretation tomorrow. So this particular political party, I say, let's be safe. These people that are coming in, we know their mindset, we know what they do, we know what politicians do immediately they win election under a particular platform. They will now quickly jump to another, especially the party that is in power. So sign for us in an affidavit, saying we are not going to, because that affidavit is a court document that can also make you to be culpable criminally if what you have said is you go and do a different thing entirely. Are you following me? So they now commit them with that affidavit. As I said earlier, it's going to be probably tomorrow a subject of judicial interpretation. But for now, that is a safe measure that the party is adopting to avoid a situation where people will use their platform to win election and tomorrow jump ship.
Does it go against the freedom of association like we have in our constitution?
Freedom of movement.
Well, see, that's why I say it's likely going to be a subject of judicial interpretation. Let me tell you, a free right that has been guaranteed under the Constitution is still subject to limitation. It's not
Absolute.
beautiful. It says if a law is made, a reasonable law is made for the safety, for the security, for other good reason, good policy, for the safety of society, then that law cannot be validated because of the fact that it restricts your right. So right is not absolute. If that right, if any law is made or a step is taken, that is very democratic, that shows reasonableness for a society to succeed, then it will be.
But in terms of the freedom of association,
yes, sorry.
A politician just felt he can no longer be comfortable where he is.
He is.
And jumping to another political party.
Then he must give reason. Remember, you have to give reason.
Of course, but does not injure the other party members.
No, they don't. So the point is that the party is saying, you use us as a platform.
You paid.
Agree. But you have used us as a platform. So if you want to jump to another, give us reason why. That's why the Constitution says.
And the Supreme Court has said,
yes,
the ticket belongs to the party.
Yes. So if you are jumping, give us reason why you are jumping. Your movement, we are not restricting it, but you have joined us. You are willingly joined us. So why are you not jumping? Because of the fact that you want to probably belong to a winning party and all that. So he's saying, sign for us that when you come in, you are not going to go. So if tomorrow the Supreme Court says that it was a wrong procedure, or that it's unconstitutional, or it's an invalid, he has restricted the right guaranteed by the Constitution, we now know that the court has made a pronouncement for. But for now, it's a safe measure for the political party to guarantee that their members will be retained if after they have won.
And the members can challenge that later, right?
That's what I'm saying. They can. Politicians, they will agree anything. Just like
I know what you want to
a promise a woman makes. He makes a woman.
A man makes a
woman. Makes a woman. So
they can. Are making
I agree with you.
Now, I'm happy as we end with
yes.
that activist judiciary.
Yes, sir.
Because of this situation, extraordinary situation we have found ourselves, and it also behoves on the media to also become activists, the activist media. Gone are the days when you sit back and say, of course, for instance, because I've said, you can express opinion.
That's right.
Using the broadcast media, not the Constitution guarantee. Before we are held back. Oh, don't say it. Oh, don't do this. Because of where we have found ourselves, the media, civil society, judiciary, public servants, everybody has to become activists. To save our nation from this.
I did a comparative analysis. I went, India, Kenya, if all these countries with really broad standing in public interest matters and activism, judicial activism, if you see their level of development, we started with India. If you see where India is today, if you go to India today, you marvel. Even Kenya, I went to Nairobi. If you see the level of development, even in South Africa that are driving us back, they have made some level where there is this activism, where government action is being questioned. People demand accountability, ask questions, and the government, whenever they want to take a decision, they know there is a lively court. That court can invalidate our action. They become very careful, and so want to tread on the part of legality and rule of law. So any society where you have issue of activism, imbibed by almost all the citizens, governments are always very careful to do the right thing, and you see high level of development. I even recommend it for further studies.
Okay.
Go and watch these countries where there is judicial activism, especially with public interest matters.
Yes.
They are far ahead of many countries.
But when the executive build houses for the judges, give them big part.
Okay.
It's another course you need to study.
Yes.
Does it affect these things they do, welfare services they render, give them car, give them houses, and make them very comfortable? Can it be a reason why, even in public interest cases, the judges now are distinguishing between violation of constitution and violation of executive act, like corruption? They now tell you that you must establish personal injury. But when it comes to issue of disobedience to constitution, they tell you, we can give you broad standing.
Okay.
They said it recently in the case of Ganifa Emi versus Okonjo-Iweala, where the court says, if it involves violation of constitution, we'll give you broad standing. But when it comes to executive action they are challenging, you must establish.
A lot of cases thrown out because you don't have locals.
Yeah, don't have
locals. Is that we must save Nigeria.
We must save Nigeria.
We have to thank you so much
that is it.
for joining us today. Well, let's quickly go to our mails now. I hear from you. Have heard from our guests. Have heard from us. Let's hear from you. And we start with Sivoma Ofozo from Lagos. And he's on the State of the Nation. He says it's so sad that Orire school children and their teachers are staying in captivity in Oyo State till date and still counting. Interestingly, Governor Makinde has said he will risk his life to save the children. Good statement, but the question is how, as he has no power over security that is controlled by the federal government from far away Abuja. Sadly, some soldiers were killed by terrorists only on Tuesday at the NIPS, National Institute for Policy and Strategic Studies, Kuru, Jos, Plateau State. Who and where is safe in Nigeria? Unfortunately, the government is more interested in politics to grab power than living up to its constitutional responsibilities of the provision of welfare and security for the citizens they are leading. It is against this background, he concludes that I maintain without blinking eyes that total and sincere restructuring of Nigeria remains imperative for true federalism to be operational. The next one is from John Peters in Port Harcourt, River State. One thing many Nigerians find difficult to understand is the selective use of the phrase Nigeria is a sovereign nation. When foreign countries offer advice on governance or security, we are quickly told that no one can dictate to Nigeria, that Nigeria is a sovereign nation. But when the IMF recommends policies such as fuel subsidy removal, electricity tariff increases, or new taxes, implementation often comes swiftly without any recourse to the sovereign nation music. Today, Nigerians are battling a rising cost of living, and now there are fresh talks about taxing fuel and telecommunication services, as recently advised by IMF. The question is, if Nigeria is truly sovereign, why is some foreign advice rejected, why others are adopted without hesitation?
Okay, Danjuma Ogu from Sabon Wuse in Abuja, the Nigerian capital, is writing in. My take this morning is for President Bola Ahmed Tinubu to implement a grant disbursement scheme. The money should be sourced from the Western countries to support the poor people without further delay. I respectfully advise that the grant disbursement be approved and signed without unnecessary delay, as it will contribute significantly to economic growth and development. The timely release of grants will support businesses, create employment opportunities, improve infrastructure, and stimulate productive activities across various sectors of the economy. Now, Eru Otto Noel from Yola in Adamawa State has written in. When the news broke yesterday evening of the suspension of the judgment made by Justice Lifu by the Appellate Court on the directives to INEC to deregister 5 political parties, I was elated with joy within my heart. Morally speaking, this decision by Justice Lifu, even though may be right, would have brought up an avoidable disastrous situation in our polity going by the timing. Good enough. Even the INEC itself reacted in a manner that seemed not to be in agreement with the decision made by Justice Lifu. This, to me, has also vindicated the executive of having a hand in all of these, except they may have been quickly advised by the true voice of reasoning of its implications ahead. I'm wondering what would have happened if INEC had gone ahead quickly to implement the judgment just like they did within seconds when the courts granted the hearing of the non-recognition of the David Mark leadership of the ADC. Eroto Noel from Yola, Adamawa State.
Thank you so much for the mails, and thank you also for being part of the program today. Our final thanks to our guest for today, Comrade Monde Obani, senior advocate. You were a comrade before.
Yes, I have not lost that title.
Okay, so you're an activist, senior advocate of Nigeria. My colleagues, Mustafa Mohammed and Shola Jasmine. Thank you so much, and have a good time.